world are duty bound to condemn this open threat to commit a war crime. They should call it ethnic cleansing, because that is what he is threatening. There should be no equivocation or conciliation with this madness. What he is threatening is to invade Gaza effectively and to expel its entire population. And he's made this threat while sitting beside Benjamin Netanyahu, who has an arrest warrant out for him by the International Criminal Court for war crimes. So the world needs to stand very clearly against this dangerous madness that is now being promoted by Donald Trump. We need the Taoiseach to condemn it in the strongest terms. We think we should be calling, our government should be calling for the indictment of Donald Trump now for threatening criminal actions against the people of Gaza, which would lead to another bloodbath, which will embolden Netanyahu again to attack the people of Gaza after 16 months of horror they have inflicted against the people of Gaza. He's threatening to do worse now to a people who actually have the right not just to return to their homes in Gaza under international law, but actually have the right to return to the homes from which they were expelled in 1948 in what is now called Israel under international law. So he is threatening to breach multiple aspects of international law and commit multiple crimes against humanity, and the world needs to wake up to what a dangerous threat Trump is, and indeed Netanyahu and the Israeli regime. The Irish government should be immediately telling the US administration that they are withdrawing facilities for the US military at Shannon. There should be no question of backtracking on the Occupied Territories Bill. If anything, these absolutely outrageous threats need to be met with the strongest possible condemnation and with moves to impose serious sanctions on the Israeli regime for the crimes it's committed against the Palestinian people, particularly in Gaza. So we will be making those calls this week in the Dáil. The other thing I just want to say, obviously Paul will talk in a bit more detail about the whole issue of speaking time and the aftermath of that debacle, but all of that has obscured many substantial issues that we think need to be urgently put on the agenda after months of delay of proper Dáil meeting. And in particular, we want to highlight the fact that it's now pretty clear that Fianna Fáil and Fine Gael lied to the public, won votes on false premises about the issue of housing and addressing the housing crisis in this country. They repeatedly stated that there was going to be 40,000 housing completions in 2024. The CSO last week now confirmed that in fact the figure is going to be just over 30,000. So almost 25% less houses built last year than the government claimed were going to be built during an election campaign. The experts are saying that it's very unlikely they will get much above 32,000 in the current year, when they themselves have acknowledged finally that we need on average 60,000 houses a year in order to get anywhere even close to addressing the absolutely catastrophic housing and homelessness crisis. And of course they're proposing only a tiny increase in the social and affordable housing targets, when they've acknowledged we need double the amount of housing that they actually had proposed under Housing for All. So we are going to see the housing crisis hit this country really in a horrific way over the next year or two, but it's all been based on a government that has lied and deceived the public about what was actually happening with the housing crisis in this country. So we urgently need the government to give us answers about what is actually going on in housing, and whether they're going to admit that they've lied to the public, and what they're going to do to address this absolutely horrific housing crisis that sadly looks set to get a hell of a lot worse based on the figures that are now available.
So hopefully today we can actually resume the key discussions that need to happen in this country in terms of, as has been said, the housing crisis, schools place crisis, the fact that thousands of people around the country are still without power, and also, of course, the horrific comments last night from Donald Trump. We need an urgent statement from the Taoiseach in condemnation of those comments, which I haven't yet heard. We had two psychopaths sitting in the Oval Office with a log fire burning behind them, talking about the ethnic cleansing of thousands of Palestinians, blithely, as if it just didn't matter, talking about real estate profiteering and just wiping out Gaza and Palestine. And we need a very strong statement from Micheál Martin in condemnation of that. Now, earlier in the month, we heard that the Irish government's strategy with Donald Trump was to love bomb him, to send him, lovely messages, hoping that he would just suddenly change tack. Is that still the case? We need to find that out, because there's been a very hands-off approach to anything that Trump has done. So today there will be a discussion in the Dáil on the Occupied Territories Bill, pushing the government to enact it. It's clear that the majority of people in this country support that, but that the government is backing off because of fears in terms of the corporations and in terms of the Trump and the regime. So I think that's an absolutely key issue today in the Dáil. Secondly, in relation to housing, the fact that the government set themselves such low targets in the first place, but then don't even reach them, is no surprise to me. I spent many years on Fingal Council, which has a huge part of the housing crisis in Dublin. Land banks are sitting idle. One huge land bank, for example, that could build 7,000 homes has not been developed. We've about 7,000 people on the housing list, so we have the land and the means to resolve this huge social cancer in Ireland, but it is not being done by this government. And then just lastly, if I could mention that I've been contacted by a lot of parents in Dublin West about school places once again, and that may not come up in the Dáil today, but it's going to be an absolute priority of People Before Profit Solidarity Group, because we've been involved in campaigning in communities on the issue. And so, for example, I've got a 13-year-old boy who was promised a school place in September, got his transport sorted and everything. That there's no teacher, there's no SNA, and there is no building. So, we have to hold the government to account on those issues, and we certainly will.
Thanks. Yesterday, one of the government's attempted strokes with the Lowry Group came to a shuddering halt, thanks to the ruling of the Ceann Comhairle, and I think really thanks to the robust opposition of those of us who are actually in opposition. Thankfully for now, this attempt for the Lowry Group to be in government, get the benefits of government, be inside government, vote with them, good days and bad, and get the benefit of speaking from opposition leaders' questions and so on, has been halted. We'll see whether the government will come back again, following Lowry once more, to find another way to facilitate him. If they do so, we will obviously oppose it strongly again. We are determined to oppose every aspect of the strokes that this government is involved in. This is a government that is based on jobs for the boys, and it is overwhelmingly boys. It's based on the expansion of extra allowances. They're going to bring into the Dáil today. They're going to try and have it without pre-legislative scrutiny, without any debate. They're going to try and pass a law to create more super junior positions, more junior ministerial positions, to allow more snouts at the trough of government. But perhaps the biggest stroke of all, and it's obviously been going on for quite a long time now, is this stroke of super junior ministers. They are junior ministers who act as senior ministers in effectively every single way. They get the extra allowances, they bring memos to Cabinet, they sit at all Cabinet meetings, participate in all the discussions. The Constitution is very, very clear, where it says the government shall consist of not less than 7 and not more than 15 members. The Constitution also is very clear in terms of the Cabinet operating collectively and the Cabinet operating on a confidential basis. All of those things are breached by the existence of these so-called super juniors, simply to facilitate a spreading around of the spoils of office. Leo Varadkar gave the game away the week before last in the Sunday Times, where he spoke openly, wrote openly about the addition of super juniors being to get around the rule of 15. And this, speaks volumes about the approach of the government, which is to say rules are not for us, they're for you, and we will simply try to get around those rules. We want to oppose the stroke politics of this government in every possible arena that we can. And that's why yesterday I initiated a plenary action in the High Court seeking an injunction preventing these super juniors, so-called, from attending cabinet meetings and seeking an end to the extra allowances that they are paid. We think it's vital that we hold this government to account. We think it's vital that we oppose these sort of strokes in every possible arena that we can. So that's why we initiated, or I initiated the High Court action, and we hope that it's heard extremely urgently, because this morning, presumably, or was it yesterday morning, they whenever they have their cabinet meetings, the super juniors are attending, acting as cabinet members, when clearly they're not, and it is against the Constitution that they are. If they want to bring in a constitutional amendment, absolutely fine. But then you have to bring in a constitutional amendment, you have to win a referendum to do that. You can't simply just get around the rules.
Whatever about the merits of the case that you're trying to bring, Paul, you've been a member of Dáil Éireann for 10 years, and there's been 3 or 4 different governments that have been installed in that time that have all had so-called super junior ministers. Why have you chosen to bring it now and not before?
If I had a time machine, I would go back into the past, and I would take a case before now. Certainly I became aware of the strength of the legal arguments against this, like a very, very clear case that this is unconstitutional, in the last month or so. And then when I became aware of that, I was been in a process of discussions with lawyers over the past 3 or 4 weeks and working out the best possible way to bring it. So I think doing it now is better than waiting and allowing this to continue. Also because this government is really taking the strokes to the maximum level. We now have 4 super junior ministers. And someone has to call a halt to this, and obviously as TDs we're in a unique position to attempt to do that.
Is there a difference between your own case and that case taken by Sinn Féin?
Yes, so this is a case that is complementary to Pa Daly's case. I'm supportive of Pa Daly's action, but effectively when we were sitting down with the lawyers and working out how to take this case, there's 2 routes you can go. One is the route of a judicial review, which is the route that Pa Daly has taken, and the other is what's known as a plenary action, which is the route that I am taking. The significant difference is that a judicial review will take place in almost all circumstances without oral evidence, without witnesses being called, purely on the basis of written legal argument, and a judge will decide on it. In a plenary action, there will be oral evidence, and crucially for us, there will be the capacity to call witnesses. And we can think of a number of people, without getting into it, that we would like to call as witnesses to explain where the super juniors came from, the rationale of it, and to outline from our perspective how it is a stroke that is against the Constitution. The second important difference between our case and Pa Daly's case is that ours seeks an injunction to stop the super juniors attending cabinet meetings, and that gives it an urgency, because we're saying it's unconstitutional for attending, they shouldn't be attending, and therefore we'll be seeking for this to be heard very, very quickly. We need to discuss with the lawyers and work out exactly what we'll do. We don't have a final strategy in terms of what witnesses or whatever, but there's a lot of people that you can imagine would be interesting to get in the witness box.
You mentioned Leo Varadkar in that piece you wrote in the Sunday Times, which you say kind of gave the game away on this. Surely then you would be expecting, or you would be calling upon Leo Varadkar to come and present at any possible trial, would you?
I will take the advice of my lawyers on that.
Do you think it would be worth hearing from?
So as purely as a layperson, yes, what you're saying sounds like a good idea, but I do need to talk to the lawyers about whether that legally makes sense in terms of the case.
Well, the Attorney General has said in relation to the Pa Daly case that the argument is simplistic but false in terms of the equivalence between, just ministers sitting in cabinet and then ministers in government. Likely going to be the same argument in your case. What's your view on that?
Well, I think the first thing I'd say is that I think, it's not a personal question, but I think the Attorney General has a responsibility here that he has neglected. It's a point that Fintan O'Toole made in the Irish Times, which is that the Attorney General has a duty to ensure that the Constitution is followed. And successive Attorney Generals have gone along with this fiction of super juniors who in reality are cabinet ministers in all but name. He made the case yesterday that is a simplistic case. I think it is simple. I literally think people can go and read the relevant articles of the Constitution, Article 23 in particular, can compare it to the reality of what happens. I do think it's simple. We'll see. Ultimately, it'll be for the High Court to decide whether we're right on that or whether he is right on that.
Is it more about the allowances than them actually sitting?
No, it's both. It's about the getting around the Constitution to facilitate this spreading of the spoils of office. And those spoils of office are the allowances, but it's also being at cabinet. I mean, clearly in terms of this government, the super juniors are an important part of presumably the relationship with the Lowry Group. If the court were to rule in a few weeks' time or whatever that super juniors cannot attend anymore, it would create a real problem for this government and the deal they have with the Lowry Group. This is part of access to power, access to being at cabinet and so on. So it's also, we think that is also crucial. Because again, the Constitution is clear, a maximum of 15 members of government, and they're effectively acting as members of government.
But the Constitution hasn't changed in the last few years, so is this just a manoeuvre to prize the government parties in the courts?
No, like I said, if I had a time machine and I could go back and take a case...
Have you not read the Constitution before? The numbers are clear.
Sure, they are, that's true, yes, and like you make the case that it's simple. I guess, to be honest, as a TD, I was elected here on the wave of the anti-water charges movement. We were involved in the struggles against austerity, we were involved in the struggle for repeal. There was a lot of things that were on our mind, and just being honest, this constitutional argument making the case that this is unconstitutional wasn't really to the fore of my mind. Perhaps it should have been, but better late than never, I would say.
Have you liaised with Sinn Féin
Have you liaised with Sinn Féin?
You have a similar question.
Yeah.
We started looking into it, I would presume, around the same time that Pat Daly was looking into it. And obviously he launched his challenge earlier than ours. I had a brief chat with Pat Daly this morning. Like I said, I think these cases are complementary. We're supportive of Pat Daly's case, but they're not coordinated. But I think they do complement each other quite well in the sense of there's two routes to go. He's going the judicial review route, we're going the other route in terms of the plenary action, and we get the benefit potentially of oral evidence and witnesses.
So Paul, you wouldn't rule out having your lawyers call Leo Varadkar as part of your case. And was his piece in the Sunday Times an instigator this year? Because within days of that being published, Pat Daly started his case, you were starting yours. And also, are you taking the injunction route because it would be quicker than JR?
Firstly, in terms of was the Leo Varadkar article key in terms of us taking the case, we were already in discussions with the lawyers before Leo Varadkar published it, and there already had been Owen Daly's article in the Irish Times, and then Fintan O'Toole's article came out after the Varadkar article. I think we've already been considering it maybe for a week or so at that stage. But I would say Leo Varadkar's article copper fastened it for us, because now we have it in writing from a former Taoiseach that effectively there's no distinction between super juniors and like full ministers, with no votes taken at cabinet, and explicitly saying this was done to get around it. So I think even without Leo Varadkar's article, we probably would have still gone ahead with the case, but certainly it would have weighed in favour of it. We think it's quite strong evidence. Secondly, in terms of this route, the two reasons to go this route is, one, yes, the injunction potentially in terms of speed, because we think this is urgent. I think Rossa Fanning, the Attorney General, yesterday was kind of arguing this has been going on for a long time, there's no urgency here, but we're saying it's unconstitutional today for the junior ministers to have been attending cabinet. Next week it'll be unconstitutional. This is urgent, even if it has gone on for a period of time. So one, the case of urgency in terms of the injunction, and secondly, the ability to have witnesses called.
Is the injunction the end point of the plenary action? Does it come along the way? Is that the goal of it?
So there's effectively 4 things that we are seeking. 1, an injunction preventing the junior ministers attending. 2, a declaration saying that decisions that are made while they are attending are not in line with the Constitution. 3, a declaration saying that the extra allowances they're paid are unconstitutional. And 4, a declaration that them attending cabinet is unconstitutional. So they're the 4 things. It is possible, and that's we need to consider and discuss further with our lawyers, we may seek a kind of early injunction, an interlocutory injunction, while we're waiting for the substantive hearing, which would then mean you're discussing that in particular in advance of the rest of it. But that's something we'll consider and probably decide on in the next week and a half.
Won't be retrospective.
It's not what we're seeking. We're only seeking it in terms of this government.